Welcome to Witham Sounding Board, a podcast sharing powerful business tips, insights, and trends for those seeking to become a rock star in their industry.
Hi, I'm Joe Holman, ESG's practice leader at Witham Advisors, and I'm joined here with Dan Viola, the SEC practice leader at Sadis and Goldberg. Thank you, Dan, for coming on.
Oh, thanks, Joe, for having me. Always a pleasure, and looking forward to speaking about ESG with you today.
So a lot's happened since our breakfast back of several months ago. So why don't you tell us what updates there might have been with the SEC and go from there.
Sure. I really appreciated being invited to your event at the New York Athletic Club. I thought it was a great venue, and we had some, wonderful speakers, and I was able to sort of learn a lot about what the climate of investors and managers in our space were looking at for ESG. From my perspective, the SEC is very focused on disclosure, and they propose disclosures for ESG in prospectuses, annual reports, investment advisor brochures, and the form is broad enough, and the questions are broad enough to cover forms NCEN for a registered investment company, and form ADV, part 1A for investment advisors, and also different types of brochure supplements like the part 2A and the part 2B. So basically the SEC is saying, we want to get feedback from the industry on what needs to be disclosed for those managers that are expressing that they take into account ESG factors in their investment strategy.
I was going to say, now we're sort of at the same spot, back in the fall when we did this. Has there been any update or word from the SEC when they're planning on divulging their plans in terms of disclosing ESG?
Yeah, so I tried to follow up to see exactly where this proposal is with the SEC, and I think they had some technical comment period issues, and they went back and extended the comment period to allow for additional comments. I think most of the comments are pretty positive and straightforward. I think there's a need for disclosure in this area. The SEC wants to avoid the greenwashing, people who are saying things about ESG just to bolster their market share, or trying to get some, investors to put money into their funds, but without really taking it seriously or having the right procedures in place. So I think we're going to see some more comments, and I think we're going to see the SEC provide some guidance and might, maybe change the proposal. But I think we're looking probably at the end of the year before we see any real firm delivery of guidelines or rules from the SEC.
Okay. I guess this greenwashing issue follows up with them putting ESG as an exam priority in their last release. Yeah,
that's correct. The SEC exam and enforcement priorities. We've been able to review some feedback from the SEC regarding those exam priorities, and ESG is front and center. Along with cybersecurity and crypto and a lot of other issues, but ESG is definitely something the SEC is concerned about.
Now, moving on from that, you mentioned crypto and ESG. It's almost like those are two really bad words these days. Congress is at war with the ESG. They are now, both House and the Senate passed resolutions the end of last month, beginning of this month, trying to change the U.S. Department of Labor rules around the ESG rule, where pension funds can invest in ESG. What's that mean to the world of ESG I know you're not an ESG attorney, but what's that mean for pension and 401k plans?
Well, I think there's a split here. I think the states are really fighting over whether or not ESG factors should be considered and raising assets or being part of an investment strategy that might impact the returns. And we've seen a split with the states. And, I think that some states are going to prohibit investments in ESG related funds, especially if there's exclusions and types of disclosures that indicate that there won't be or there will be some impact on ESG factors in the portfolio.
Do you think the fiduciaries of these pension plans and 401k plans are going to be hesitant about offering them to their employees, or certainly on the 401k plans?
Yeah,
an ESG fund?
Yep, I think that's going to be a real issue depending on what state the plan is based. It certainly raises the question. I think, if you ask 10 investors in a 401k or something about what's most important to them, I don't know if it's going to really be the environment or social or governance or equality with respect to the workplace. I think it's most people are concerned about those issues, but if it's going to impact their portfolio in a real material way on the downside, I think they will be upset. And I think there's a subjective standard involved, and if somebody's making the decision that's real pro environment, then that might conflict with some of the other people who are invested or maybe have money at stake because they're in directly in the pension plan. Those issues are going to be ripe for conflict and litigation.
Now, you mentioned the states. I mean, the states are all over ESG, especially the state of Florida, where they're actually issuing language for managers. Florida pension plans are issuing languages to managers not to use ESG with the investment process if it affects returns. So it specifically says that they're prohibited from using social, political, or ideological interests in developing their portfolio if it affects returns. I mean, that's got to be scary for all of the funds out there that are ESG compliant. I mean, what kind of damages can a manager suffer by accepting money like this when they have ESG plans?
Well, I think the downside would be, if they don't really fully understand the state restrictions or mandates, they could be facing a lawsuit for violating the objectives or restrictions of that particular client or investor if it's going to be more memorialized in a side letter. So, I think by analogy, Joe, we talked about this a little bit before. A lot of clients said, I don't want to invest in big tobacco. I don't want tobacco stocks in my portfolio. And for years, it was sort of just an acceptable statement, and now here's something where somebody says, I want environmental protection. I want environmental efforts in the portfolio. And it's involving, some sort of analysis of a political nature. And, ultimately, I think the fund managers are going to have to decide, how they're going to direct their portfolio. But what they can't do is say, we are pro ESG on one hand, and then take somebody's money from like a Florida pension plan that says, we're not going to utilize ESG in our portfolio process. So now you've got a stark conflict between what you told investors and what's actually happening, and that's exactly what the SEC would bring an enforcement case on.
So you think the SEC would look down upon me as a marketer telling, say, the Sovereign Wealth Fund of Norway that we don't invest in oil and gas, and then we tell Florida that we invest in everything and we love oil and gas? You think that they would have a problem with that?
That's exactly what I was trying to say, Joe. It's you have to be consistent with your investment objective process. You can't just have a policy that says one thing and you don't follow it. And it's going to draw a lot of conflict with trying to select maybe a non-US based manager to oversee a fund. There's a lot of instances where Europe is so much stricter on ESG, and they mandate this process, and they have rules in place that are, I think, way advanced compared to what the SEC has done. And the SEC's rules are largely based, I want to say, on some of the European standards or the non-US standards. So, there's going to be a tremendous conflict. And I think the managers are going to have to really evaluate the mandates of those pension funds state by state.
Yeah, that's a good point where these pension funds of Florida and Texas and other states might be blocked, prohibited from investing in the European funds who, through the EU taxonomy and SFDR, factor in and prohibit oil, gas, guns, and the other, political topics of the day here in the U.S. So I don't know where they're going to go with that. But from a SEC, not SEC obviously doesn't want you to talk out of both sides of your mouth. But what happens if the state of Florida challenges you and says that, how could they prove non-compliance?
So there's two ways I think they can do that. They can look at your offering documents and see what kind of representations you have in your investment strategy, or your investment description in your Part 2A, your brochure, if you're a registered investment advisor, in your marketing materials. You might have a due diligence questionnaire that you filled out, or you might have a PowerPoint slide presentation that talks about these types of factors. And if you have a reference of some sort that talks about how you're going to utilize ESG in your process, and you're adhering to that, it could be a problem with a state pension like Florida or Texas. Likewise, if people relied on your ESG analysis or your objectives in connection with including ESG related factors in your portfolio process, and somebody decides that they're not going to do that, that's a lawsuit waiting for the other side to happen.
So you think there's actual economic damages more than just the investor leaves the fund?
Yeah, I mean, the damages are going to be based on, experts. So whenever there's a lawsuit and there's a success or a victory, there's a damage calculation as part of every lawsuit. So, that's usually done with experts. So you'll have one expert that comes in and maybe compares the portfolio to, if something didn't include ESG related factors, and maybe they take a group of securities that are outside of the ESG framework, and then they do an analysis on how that would have performed with plus or minus some sort of averages that they assume, or certain assumptions they disclose. And then the other side takes an expert and sort of contradicts that review and states their own type of. But at the end, the judge or jury determines whether or not the damages make sense and how much should be awarded.
So it could be quite expensive if you said you didn't boycott oil, but you did, and then oil like last year was up 70%. It could actually be quite an expensive mistake that your marketing team made.
That's right.
So, well, with that in mind, what can managers do about this? Because there's economics involved, there's, reputation involved, and this is at the core of their business, which is their investment strategy.
Yeah, I think there's two solutions there. I think you got to, talk with your counsel about how your disclosure looks in your offering documents, and not just the final, version of the private placement memorandum, but your Form ADV, your marketing materials, all those have to be reviewed carefully. And then training, the second point is training. You have to train your marketing group. You have to sit down and explain, what's happening in this sector and how sensitive it is, so that there's no evidence that could be obtained through discovery that might indicate that you were talking about ESG factors only to, win a mandate, when in reality there might be evidence that you have memorialized with an email or a text message where you were basically saying things contrary to that marketing pitch just to win over the assets. And that's a classic greenwashing. The SEC is really concerned about people who mislead the investors. They want to protect those investors. They want to make sure that managers are allocating their capital efficiently. and consistent with what they're disclosing to those investors.
So I guess really a good review of the documents, not just your PPM, but your marketing documents and your due diligence questionnaires that go to the investors and prospects. Have your counsel look at that. And then just my last question is filling out Form ADV. We know that the SEC is looking at people to put managers to put ESG in there if they use it in their investment process, but are managers currently just putting it in their Form ADV today, in like the brochure, the Part 2A section, just to disclose it?
Yeah, that's a good point. There's currently disclosure already that managers are putting in to their Form ADV or their offering documents that really highlight ESG. Most of that disclosure centers around how ESG will be used in the portfolio, and that it is a vital part of the portfolio, and how the firm is also implemented various procedures to make sure that they're internally at the investment manager level complying with certain environmental standards, and maybe they're part of a PRI grouping, or they're trying to be certified in an area. So there's a big push for disclosure already, but the new proposed release from the SEC that talks about additional disclosure is really drilling down to each one of these strategies and asking specific questions so that they can to really make sure investors know what the investment strategy looks like with the ESG factors.
Well, with Form ADV due in 20-something days, this is probably pretty relevant for managers to think about and give people like you a call. Any final thoughts you have, or you want to say to managers, pension funds, regarding what's happening in the world of ESG?
Yeah, just keep in mind that this is an SEC hot topic, and your disclosure is imperative in this area. And if you have questions, reach out to counsel or to your consultant. Anyone that has a background on this, so that you can be fully informed.
Well, thank you, Dan, and I hope to have you on again, and we can discuss this when these rules have been updated in probably 90 to 180 days from now. So take care, and look for our next session.
Thanks for joining us. Be sure to subscribe to our podcast so you'll be first in line to hear what's coming next. Don't want to wait for our next episode? Check us out at withum.com. That's WITHUM.com.